Fortunate for us, despite the technical glitches, we are able to bring him back onshore virtually for an hour. Chris has a passion for history, and today I would like to invite him to share his story with us. As you can imagine, there are many chapters to his story. I, like any conscientious lawyer, did some research into what entails a good story. And I know that there are 6 elements: character, setting, plot, conflict, theme, and point of view. And I will try to fulfill these 6 elements with Chris in the next hour. So let's go back to the very beginnings in Vancouver. The setting, a bustling West Coast seaport in British Columbia, where Chris was born, where I assume Chris was bred, and where Chris grew up. So Chris, tell us, have you always wanted to read law?
No.
That's a very good, straightforward answer, which we hope all winners would give us, but they don't. So no, picking up from that.
I didn't want to be a lawyer from the beginning. I went through lots of different things that I wanted to be. I wanted to be a hockey player. I thought I would like to be an anthropologist. And I ended up doing international relations and political science in my undergraduate work, and then a graduate degree. And at that point, there were not a lot of job opportunities in Canada for PhDs in political science. And my father said, you know, I've been talking to you about law. Maybe you ought to think about that. And that's what I ended up doing, was going into law school. But when I went into law school, I did it with the hope that I could combine my interest in international economic matters with law. And so I had that ambition from when I decided to go into law school, and that's what I tried to pursue afterwards.
So you are what they call an accidental lawyer.
Yes.
And I also heard of this urban myth where they say that you were a hockey player.
Yes.
Is that true?
It is true, yes.
So are you a better hockey player or a better lawyer?
I wasn't good enough to go very far in professional hockey, that's for sure. So I guess I'm a slightly better lawyer than I am a hockey player.
Okay, so after graduating, you know, with a law degree, did you what then was the next sort of step in your legal career?
I clerked at the BC Court of Appeal and started off clerking for 2 judges, and then I ended up working for a 3rd as well. And that was a terrific experience because it gives you all sorts of insight into how the judicial process actually operates behind the closed doors of judges' chambers. And so I did that for a year. I articled and worked for a firm called Ladner Downs. But because I had this interest in trying to pursue international economic law, I figured I better get out of town, because I felt that if I stayed in Vancouver, I would end up just doing commercial litigation, which would have been just fine. But I thought, I'll give it a try and I'll go east. And so I went to New York and did my master's at Columbia University. And then while I was there, a number of the universities in Canada that are looking for young law professors send interviewing teams down to the Ivy League schools. And I got recruited by University of Ottawa, which was in a rebuilding stage at that point. And I thought, you know, maybe it would be a good idea for me to spend some time in Ottawa, because it's the nation's capital. That's where trade policy was made. And I thought it would be an interesting place to live. So I decided I would do that for a while. And from there, one thing led to another.
Okay, so before we go to the one thing led to another, I want to go back to sort of your clerkship experience, because the 6 elements, we need some plot, we need some conflict. So what do you remember the most from your clerkship experience?
From my what experience?
The clerkship.
Oh, the clerkship.
Time as a clerk.
Oh, well, I mean, I'll tell you what happened on a virtually a daily basis. I go into my primary judge's chambers, Mr. Justice Seaton, who is a wonderful man. And he was the one who loaded most of the work on me. And we talk about what the court was going to be doing that day. And we just sort of talk about the case generally, not really forming any opinion at all. He was pretty careful about that. But in those days, the Court of Appeal gave a lot of judgments orally from the bench. So any one of the judges would be called upon by the presiding judge to deliver oral reasons if they wished. Then we go into court. And in those days, there was a fairly small cabal of senior lawyers who dominated the work in the Court of Appeal. And they were all pretty good, but they all thought they were very, very good. And it was what was really interesting to me was to watch them and then go back and talk about their advocacy styles with my judge. And of course, the lawyers would think they were making great points. During coffee breaks, they'd think, oh, we really scored a big point on that one. And then you go back and listen to the judges talking about, and you get a very different perspective on how well the lawyers were doing. But I think for me, what was really interesting was to see the interpersonal relations between the judges and how it was that a collective body of judges would come to arrive at a decision. And I realized very soon that the law at the end of the day, especially in a court of appeal or in a Supreme Court of a country, very much is a process of negotiation among differing views of the judges when they strive to achieve a unanimous decision. And I used to, after I had worked at the Court of Appeal, I used to think back to my law school days where, you'd have a law professor who'd say, look at this statement the court makes at paragraph 54, and look how it's so differently expressed in paragraph 178. How can we reconcile this contradiction or this inconsistency? Well, the answer usually is that paragraph 178 was written by one of the judges and 54 was written by another, and they cobbled together a result which they felt was satisfactory in the circumstances of the case. And so that was a real lesson for me in terms of how judges approached things. And what it also helped me learn to understand, not that I was particularly good at it, was the ability of an experienced judge to cut to the essential point and to focus on the essential point without being distracted by what were really, at the end of the day, irrelevancies or subsidiary points. And that was a real lesson for me. But there wasn't a lot of conflict because I was a very obedient clerk.
But that's really good because you see, analogies can be drawn with sort of how 3-member tribunals work in international arbitration, the sort of interpersonal relationships amongst the arbitrators, and the clerkship is somewhat akin to a tribunal secretary, and what sort of benefits you can draw from being a tribunal secretary to a panel of arbitrators. Yes, and clerking is a great way to start off your legal career. There's no doubt about it. So one thing led to another. You decided to leave the bustling town of Vancouver, spend some time in Ottawa. And what were you teaching there? Were you teaching at a university? Yes, I was teaching at University of Ottawa, which has 2 law schools, actually. It has a civil law school and a common law school. I taught in the common law school. And one of the attractive things for joining that faculty was they had a pot of money. And the dean who interviewed me said, we talked about what I might do. And I said, I want to design a couple of courses in international trade law. And I'd like to get some money to start a conference. And so he said, great, no problem. So he gave me what seemed to be a lot of money at the time. And what I discovered was, as a young law professor, being able to invite people to speak at the conference was a great way to open doors. And so I was able to meet a fair number of people in the Canadian government. I was introduced to people in the US Trade Representative's office. And so I started this conference, and I don't know if it's still on, but 10 years ago it was still on, and I had long since left University of Ottawa. But it was a great way to meet people. And that actually turned out, oddly enough, to be
a very important turning point in my career. And what happened was I spent 2 years there, and then my dean from University of British Columbia called me up one day and said, "It's time for you to come back to Vancouver. We want to hire you at UBC Law School." So I said, "Okay, I've had enough of these cold winters. I'll move back to Vancouver." So I moved back to Vancouver in May of that year. And in June or July, I got a call from Ottawa. And there had been a new Minister of International Trade appointed. The Canada-US free trade negotiations were just getting underway. And they asked me if I would come back and interview for the position of senior advisor to the minister. And so I went, it's kind of embarrassing because I had just landed in Vancouver, but I went to talk to the dean and he was very understanding. He said, "Look, I'll keep your position open, take 2 years and go and do it. Because if you don't do it and it turns out to be an interesting thing to have done, and you didn't do it, you'd feel badly about it. So go and do it." So I moved back to Ottawa and I worked there for 2 years during the Canada-US free trade negotiations. And that was very important because in that I met lawyers from all over the place, including in Washington, DC. And it opened all sorts of doors for me professionally. For example, after the free trade agreement came into force, the first dispute to arise was a US complaint against Canada on certain landing restrictions that Canada had implemented for salmon and herring in the Pacific coast. And I ended up acting for the government of Canada in defending that case. So, it was one thing, as I said, it was one thing led to another. There was really no logic. There was no planning on my part. It's just that, I did the job with the FTA, then I got the job representing Canada. Then somebody said, "Would you like to be appointed to a GATT panel?" So I did that. And then a few years later, the Mexicans came along and I ended up acting for them in the NAFTA negotiations.
Yes, but but that in itself also tells us a lot about grabbing every opportunity that presents itself and making the best use of opportunities when, you are there at the right place at the right time. I mean, acting as advisor to the government during those 2 years must have been a very significant chapter in your life.
It was, it was education.
And I appreciate that those discussions and negotiations are confidential, but because we are trying to hear more of your story, is there anything that you can share with us from during that time when you're advising the government?
Well, I did a lot of work in the cabinet, which is all of which is secret. But part of my job involved accompanying the minister when she went to the main capitals in those days, the main capitals of the world for trade, which were Brussels for the European Union, Washington, DC for the United States, and Tokyo. So one of the really great aspects of this job for me was that often I'd accompany the minister and they would have very small meetings. There would be maybe minister plus an ambassador plus a deputy and 1 or 2 other people. And my minister was very good because she always let me be in the room. And I remember the first quadrilateral meeting, which is the EU, Japan, Canada, the United States, was held shortly after I joined the government. And we went to Portugal, which had just joined the EU. And so they were hosting it in a place called Sintra. And I just, I'd seen all these trade ministers on television and in the newspapers, and to be in the room with a maximum of about 20 people was really an exciting time, at that point, because I was pretty young to be in that sort of situation. And so that was really great. And then when we go to Washington, DC, we'd not only meet with administration officials, the US Trade Representative or the Secretary of Commerce, but we'd go up to Capitol Hill and we'd meet the chairman of the Senate Finance Committee, which had jurisdiction over trade, et cetera. And those sorts of meetings were great. I mean, because you can't buy that kind of exposure to these types of senior decision makers. And it's very interesting to see how they conduct themselves. I was lucky enough to meet James Baker when he was Secretary of the Treasury. And you watch it and see that guy is an impressive man. And so I enjoyed that time very much.
But that is, it's such an amazing learning opportunity, because even if you are in practice and you've been in practice throughout, you may never have that chance to be, in such close contact with ministers and leaders from all over the world.
Yes.
So you then left that, went back to private practice, and
Well,
then
I went back. Sorry, actually, not quite. I went back to the University of British Columbia because they'd freed me. But
they kept the position open.
yes, and so I did some more teaching, but then at the same time, what I found was I was starting to pick up retainers. For example, the fishing dispute between Canada and the United States. And my old law firm wanted me back. So we ended up working out a deal where I was splitting my time. And then that worked for about a year or two. And then I just had too much happening on the practice side. And frankly, it was more interesting than the academic side for me. And so I ended up deciding I better just go back into private practice full time, because it wasn't fair to the students to be missing the classes because I was traveling and that sort of thing. So I made a decision to focus on practice.
Yes, so you went back to your original firm, which is one of the top Canadian firms. And then again, I did my research. You decided to start your own firm. And I just wanted to, learn from you, what led you to do that? Because it is a very bold move to start your own firm instead of working in an established Canadian firm. And this is a bold move, which we do see a lot of our young practitioners taking these days.
Yeah. Well,
so what made you do that? Yeah.
All right. Well, this is it's probably not the answer you're going to expect, but I had a very close friend who was also at Ladner Downs, and we were of the same year of call, and he was a litigator and a terrific guy. We spent a lot of time working closely together. And he used to say to me, we should start our own firm. And I would rebuff the idea, because I loved Ladner Downs. I loved the partnership. I loved the lawyers there. I have a lot of good friends still who were colleagues then. And in fact, my office downtown, I subleased space from the successor firm of Ladner Downs, which is Borden Ladner Gervais. But anyway, after about two or 3 years of my friend haranguing me, one night we were having a dinner, and I think there was some alcohol involved, and finally we said, okay, let's do it. So, so we came up with the idea that we would stagger the creation of the firm, and I would go first and he would go second. That was a big mistake. So I went first and I got the firm going, and I picked up some new clients immediately, and I was able to take the clients that I'd worked for, including Mexico. So I was feeling very bullish. And then my friend got a little nervous and he ended up not coming. So I just signed a lease for 10 years, and he told me, I was in Mexico City when he phoned me and said, I've changed my mind. Our friendship suffered for a while. It's recovered, but there was a period of time where feelings were a little raw, because I was the only partner and I had a couple of young associates. So I had to build the firm up from there. So that's the way it happened. Yeah,
I wanted to ask whether is he still your friend now?
Yeah, he is. I was best man at his wedding. We did go through a rough patch there. I was pretty upset. And then finally he said, he phoned me up and he said, I think we should go for lunch. He said, I know you have a few things you want to get off your chest. And so I said, you're right. And we went for lunch and I got a few things off my chest, and everything was okay after that. And it worked out very well. I had picked up other lawyers who were terrific. And we had a good little firm. We had a firm, offices in Vancouver and Ottawa. And we had a great time.
Yeah, sometimes things just happen for a reason.
Yes.
And I guess if I were to ask you to turn back the clock with the benefit of hindsight, would you still have stepped out to start your own firm?
Probably not, even though financially, it was much more advantageous than working in a big firm. But the difference between working at an established big firm and a small firm, a boutique firm, is the big firm feels like you're on an ocean cruiser. You're on a cruise ship, and it doesn't matter how stormy the seas get. You really don't feel a lot of movement in the boat. Whereas if you're in a small firm, you feel like you're being tossed around by the waves. And on the one hand, that's more stressful. On the other hand, it's also more exhilarating. Mm. And you feel, in a small firm, I think you feel wins and losses more profoundly than you do in a big firm. I mean, every lawyer is competitive, especially in litigation, but I think that in a small firm, you feel that more than you do in a big firm. So it worked out for me. But if I had known that my friend was going to get cold feet, I don't think I would have left Ladner Downs.
That's interesting. So you then practice as counsel in numerous investor state arbitrations and NAFTA cases. And there are numerous landmark decisions to your name: Waste Management 1, Waste Management 2, Thunderbird, Metaclad, Myers, Pope and Talbot. What would be the most significant case in your view?
Well, there's three cases that I would say I found interesting, and in one case in particular was advantageous. Metalclad was the first major case we did for Mexico. And what I learned there, which is a really important thing for young lawyers, is the immense power that an arbitration tribunal has to make findings of fact. Unless they completely go off the rails, it's almost impossible to annul or judicially review even erroneous findings of fact. And in that case, we had a very factually intense case. When we got the award, we were stunned at the award, because even though it was from a very prestigious tribunal, we just felt that contemporaneous documents that had not been disputed were not even mentioned. Significant facts were omitted from the award. And so we ended up going to judicial review. And we succeeded in partly setting aside the award, but what was equally important for the government of Mexico was that in the judicial review judgment, the judge actually took what we did was we said, here are the unrebutted facts from the claimant about this investment. And we put that in, and we didn't put anything that could be contested in the brief that we filed for judicial review. And that judge very kindly reproduced what the uncontested facts were. So if you read the award and then read the judicial review judgment, you see that there was a very different set of facts that were never addressed by the tribunal. So for me, that was a really important practice lesson, which is the absolute necessity to focus on making sure you bring home to the tribunal the facts, and that you drive home the key factual points, because of the fact that you have one kick at the can in that type of case. Waste management was a very important case for me, because it was a case we were expected to lose, and we won. And we had a very good tribunal, which was chaired by the late James Crawford, who was terrific to appear before. And it really established some doctrine on the notion of fair and equitable treatment under the NAFTA. Yes. And there's passages in that award which have been cited by dozens and dozens of investment tribunals since that time. So I felt very pleased about that case and the outcome that we were able to obtain. And then the third case, which was interesting, because it's another one of these things these serendipitous events that has characterized my career, was the Linea Case. And that's probably the only case where I really destroyed a witness on cross-examination. I mean, everybody tries their best, and sometimes you get a few shots in, but I was able to, in that case, I had a good set of facts, and I was able to just to take this one primary witness of the other side apart. And, it was great. We got a win out of the case, but what it led to was 2 years later, the chairman of that tribunal was Jan Paulsen, then of Freshfields. And I got a one-line email from him saying, "Would you like to be an arbitrator?" And I had never thought of being an arbitrator, but I guess he'd remembered me from that case. And so that's how I got my first arbitral appointment.
Wow, that is fascinating. And, I guess it goes back to the point of ensuring that each and every time when you are doing a particular case, regardless of whether you are assisting the judge, whether you are working on the case in a firm, whether you are presenting the case as counsel, that you must do your best and ensure that you put the best foot forward. Having had such amazing experience and as an advocate, are you able to share some tips on how to be an effective and persuasive advocate with the audience today?
Well, there's a few points that they're simple points, and they're probably things that everybody knows, but I'll tell you what I always believed in. There's an old saying, prior preparation prevents poor performance. There's the 5 Ps. And I really am a strong believer in that the more you prepare, you never hurt yourself by preparing as much as you possibly can. And so that's issue number one. Second one is apropos of my comment about medical ed, is master the facts. You need to know the record inside out. And what I did when I made submissions, or even when I was doing cross-examinations, I was very careful to plan out my cross-examinations. I was very careful to prune them, because one of the big problems, and you see this with people who don't do a lot of litigation or arbitration, is you'll often see compound questions where there's too many elements in the question. And so people are too quick to try to ask a compound question, when what they really need to do is to ask 3 or 4 very simple questions which admit of a yes/no answer. And so what I always tried to do was to strip it down and distill it and make the questions as simple as possible. And I always had my record references at hand, so that if I had my outline of my cross on one page, on the other side, I would have corresponding record references, so that if the witness didn't give me the answer I wanted, I would take that witness to the document and I would extract the answer I wanted from the witness. And I once took a continuing legal education program on cross-examination by an American trial lawyer, and he talked about the cross-examination should be a combination of risk of pain for the witness and reward. And what you want to do is you want to train the witness that it's much less painful to answer the question than it is to try to wiggle out of the question. And so if you have the record references there, you can inflict the pain that's necessary to bring the witness back to making the admission that you're looking for. And after you've done that a couple of times, the witness will enjoy answering the question more promptly and more forthrightly. And so I really believe in that pain and reward aspect of cross-examination. And that's why you have to know exactly how you will get the witness to the point you want to get. The last thing I would say is something that I didn't figure out until very later on in my career when I was doing counsel work, was I started to realize that I should write my closing submissions before I went to the hearing. So about a month or 6 weeks before the hearing, I would write a closing. And quite careful. And the reason why I did that was it showed to me where the gaps were in my case. And it told me what I needed to get from the witnesses from the other side, what I needed to emphasize, and what points I wanted to make at the end of the hearing. Because in those days, we had a lot of last day of the hearing was you had one night to prepare and you would do closing submissions. And so I started doing that, and it made my life a lot easier, because during the hearing, all I had to do at night was to review the transcript and pop in transcript references to what I'd already written, adjusted a bit because it never unfolded exactly as I wanted it to. But it was a very efficient way to know what I wanted to achieve and to try to get to the result that I wanted to have at the end of the hearing.
I think that is a very useful tip that I may incorporate in future in my own preparation. Because it's always, you have that closing in your head, but you never quite write it out. But because you have it in your head, you know exactly what you want to do during the cross-examination. Because the worst kind of cross-examination is the purposeless cross.
Yes.
The purposeless cross that just tries to undermine the credibility, ask the witness questions on little inconsistencies, but I always say, to what end? what
Yes.
is the objective of such a course. I should let the attendees know that if you have any questions for Chris, please feel free to type it in the chat box. If it's an appropriate question and interesting enough, I may pick it up. So thanks so much for sharing those tips with us. I then want to go to the next chapter in your life, which is after your amazing time, you know, being counsel, acting both for investors and for states. You then decided to move to the sunny island of Singapore. And that was in 2012, I think. And my question, what prompted that move?
Well, I had done a little bit of work for Singapore in the early 2000s and became friends with various people in the Attorney General's Chamber and the Ministry of Trade and Investment. So one thing I've always admired about Singapore government is the extent to which they require their officials to continually do training and sort of internal education. And so I was going to Singapore about every 2 years. I'd go and do a 1 week intensive for either AGC or the Ministry of Trade. And so what happened was I got to about 2009, 2010, and I had decided, okay, I've had enough of these investor state cases as counsel. I was starting to pick up some arbitrations. And one thing when you act for a government is that, you know, it's one thing to have a $50 million claim. That's a lot of money. It's another thing to have claims that are north of $1 billion, because there's a lot of stress in defending a government. I got to a point where I thought, okay, I've done a lot of these cases and they're getting to be repetitive. And they're also emotionally quite draining to get through these cases. And so I thought, okay, I'm starting to pick up these appointments as an arbitrator. I think I might want to do that now. And so I thought I would segue into that. And so the long and short of it is that I sold my law firm to Borden Ladner Gervais. And my former partners and associates went into BLG's offices in Vancouver and Ottawa.
Oh, okay.
And so I ended up acting as a consultant for BLG, which was a fancy name for ensuring that my clients would transfer over to BLG. And so I did that. And so the long and short of it is, by that time I had enough work as an arbitrator that I was a little bit more able to disconnect from Vancouver and from Canada. And so I happened to be in Singapore for one of these training sessions, and I was chatting with a few people, and including Bob Beckman at CIL. And somehow this idea of a position being created at CIL came up. And so I went back to Vancouver. My wife was at that point a television reporter. And I said, what do you think? And she said, why not? We're in a comfortable rut. And, you know, we could both continue doing what we're doing, but it'd be kind of fun to do this. And she went to her employer and they gave her a 3-year leave of absence. And so there was no downside for her. And I signed a 3-year deal with CIL. And then at that point, the then Attorney General, now Chief Justice, I was visiting him and he said, I'd like you to start an arbitration academy.
Yes.
So I said, okay, I'll do that. And then he said, and do you think we could maybe get you to have some young Singaporeans shadow you in your work as an arbitrator so that they could get some experience? So I said, sure. So that's how I ended up getting some juniors at CIL, and that's how we ended up creating the Singapore International Arbitration Academy.
Yeah, the Singapore International Arbitration Academy is really a great sort of a product, and you know, thanks so much for launching it and pioneering it in Singapore, because I think it has really given a lot of the young practitioners an opportunity to work with different different limbs of the legal profession, because they get a chance to work with and to deal with government officials. They get a chance to do with academics, private practitioners. So I think it is a really good opportunity for them. And I mean, you have kindly invited me to speak at some of these conferences, and I've seen the participants who then go on to argue a moot before a very distinguished panel, including some ICJ judges. So this is a key sort of event in our arbitration calendar in this region now. And a lot of, I think, the attendees either have participated or would be thinking of signing up for this academy. What would be your advice to this, students or these lawyers who are interested in signing up for this academy? How do they get the best out of this?
Well, the way we tried to develop it was to try to make it as real as possible. In other words, I would spend a lot of time drafting up a hypothetical problem that sometimes reflected cases that I'd worked on, the kind of legal principles that came up, obviously a change in the facts and that, but we would try to create something which had a certain amount of realism in it. And it would be a complex case. And what we would do is we brought in a lot of government officials. So all of the ASEAN countries sent at least 2 representatives. Sometimes you get many more from an ASEAN country, but we had all of the ASEAN countries there. Sri Lanka would send people as well. And we would get all sorts of people from different parts of the world. But what we would do is try to distinguish between, first of all, practicing lawyers who were going to make them argue, and also some of the government officials who we thought would be comfortable enough to get up and argue, because obviously many of them would be arguing in a second language. And so that's a challenge in and of itself. And we wanted to respect the difficulty of that. We didn't want to inflict it on anybody, but we would try to find people who we felt had the necessary skills to be able to do it. And then we would tell them very early on. In those days, the academy would take a couple of weeks. It's now shortened, but we would tell them on basically the evening of day 1 or the morning of day 2, you're arguing, you're on the respondent, you're on the claimant side, and we would divide the academy into two teams. And they would have, and the advocates would realize, we have, say, 10 days before we're going to have to argue before, say, Chris Greenwood of the International Court of Justice, Frank Berman, name the luminary, Jan Paulson. We always tried to bring in a heavy duty bench, Lucy Reed, Judith Gill. And so we brought in heavy hitters, and the idea was to sort of get the advocates to start thinking, I need to be prepared. I've got to be ready to go in 10 days or 8 days. And so that has a tendency to concentrate the mind. And what I wanted to do was make it real. And I also helped them. I helped the teams. We'd give them some suggested lines of argument, but basically what we would do is say, every lunch break, you need to sit down with your colleagues. You need to allocate who's going to do what. Here's the issues. You need to start working on them. And you also need to coordinate amongst yourselves so that the leadoff speaker doesn't say something that's going to destroy the third speaker in the final day's argument. And so the good teams they really went all out, and they were working at night. Somebody from a law office would get a boardroom. They would be having meetings night after night to try to run through all of the materials that we gave them, discuss the facts, try to understand what the shape of the case was, and then put it all together and then argue it. And I have to say, one of the things that really made me very happy about all the academies is that we bring in these top people from around the world. And every year they would say to me, without exception, that some of the arguments they heard were as good as any counsel that they had appearing before them. And these were mainly young Singaporeans and some other people from the ASEAN states, and then also some people from North America, from Europe. But I was very pleased about that, because what it showed to me was that in a short period of time, if they threw themselves into it with a little bit of guidance and listening to the lectures, which we tried to tailor to the dispute, they would be capable of getting up and making a pitch for 10 minutes in front of a very tough audience, which they did.
It's great, because I have some colleagues who have signed up for this program, and through that they also said it's probably one of the most intense, because they did have to spend a lot of time preparing, but a great learning opportunity for them. You came on a 3-year contract, but you extended it.
Yes.
So that brings us to 6 years in Singapore. And
Yes.
like I mentioned at the introduction, you were appointed as amicus curiae in 2 of the cases. And that was when I first knew you, when you were appointed as amicus curiae. Interestingly enough, I was acting for the investors in those cases. And this may be a bit sensitive, but my clients, when they learned that you were appointed as the amicus curiae, their first question to me was, but Chris is pro-state. And I was like, what do you mean pro-state? If he's an amicus curiae, he's going to give a neutral, objective opinion. And if we feel that we are strong in these various aspects, I'm sure his opinion would support our arguments. So what is your response to this characterization by my clients of you as pro-state?
Well, what I found in this business, there's a lot of typecasting. And we're all a product of our own experience. And it is true that I have acted for states over the years, but I have acted for states as complainants as well as respondents. And also, I mean, when you go, that I did counsel work. I'm not doing counsel work anymore. When I went in as an amicus curiae, my objective was not to, my objective was to try to lay out in a way which I hope would be helpful to the court what the issues were and what the basic principles of international law were on the issue. I mean, let me turn the question back to you, Sui. Did you think that my amicus curiae opinions were unfair?
No, in fact, they were not. And I mean, it was a very neutral, objective opinion, which did not seek to opine on the final issue. But if you follow the analysis, it does, for the first case, say that the state succession principles would apply. And because of the moving treaty frontiers rules, that is the outcome, unless otherwise established. So it was the outcome that the Court of Appeal ultimately reached. And certainly it then found that the tribunal had jurisdiction. So if you ask me, I can't see it as being pro-state or pro-investor. I think it was just an objective, neutral opinion with sound legal reasoning. Which was exactly what I said to my clients.
Well, I felt like, the Court of Appeal, first of all, the Singapore Court of Appeal is a very, very sophisticated court.
Yes.
And they hardly need any assistance from an amicus curiae, as far as I'm concerned. They were not at all, none of the judges were particularly worried about the fact that there were issues of international law. And it's clear from reading the judgments of those 2 cases that they put a tremendous amount of work into analyzing the issues. And I did try to do as much, if the court were inclined to see this, then this would follow. If the court was inclined to see this, this would follow. To give them essentially a skeleton, not an argument, but a skeleton for analyzing the various issues which arose in the case on which we were asked. Because the court was very careful to pose questions to me. And I answered the questions, but I didn't want to ever cross the line between providing what the law was, where the differences in interpretation may lie, and then it's up to the court to decide how to apply it.
Yeah, but for me, it was also fascinating because it was the Longs and Sanum was the very first case that came before the Court of Appeal, and just to be involved in it and to have that chance was just amazing. So, and gave me the chance to know you. So it was great. I wanted to ask you, what in your 6 years in Singapore, what was the highlight of your time? If you could share with us both professionally as well as personally.
Well, I think professionally, I really enjoyed those amicus curiae interventions just because it was fun to go back and draft things. And it was also kind of interesting for me to learn a little bit about the rules of court and the way in which the Singaporean courts like their materials to be prepared. And fortunately, Emily Chu, who was working with me at that point, had some experience, litigation experience in Singaporean court. So she was very good at guiding me through the nuances of the way in which Singaporean pleadings are put together. So that was I liked that. And it's fun to go into a different court. And although, you know, in some respects, it's not that different from another common law court. You know, I mean, the Canadian courts at the appellate level are pretty similar, but I have to say that the intensity of preparation of the court was remarkable. So that was quite noteworthy. So that was a big highlight. And the academy, developing the academy from scratch and trying to make it interesting and challenging for the participants was, I like that. I mean, that took a lot of energy to put those things together, but it was great fun, and I'm glad we did that. So I hope that it will continue with CIL. I know they had to do it all virtually this past year, but I hope that it'll continue, because I think it's a good way to teach people about the practice in this area. Personally, I mean, Singapore was such an interesting place for us to live, because we met, first of all, we came to Singapore with the intention of not living in the expat bubble. There are many expats who go to Singapore and don't know anybody locally, and they only know them from working in the same offices. And we wanted to not do that. We wanted to make local friends as well as friends from other countries. We lived very close to Toa Payoh.
Oh, wow.
Yeah, we lived near the Polo Club, but we were very close to Toa Payoh. And we spent a lot of time at Toa Payoh at the HDB hub there. And in fact, for the first couple of years, our kids went to Kung Fu in the community center in Toa Payoh. And so they were the only Western kids, except for one other. And all the rest of the kids were from the neighboring HDB flats. And I just thought that was just the best, because they got to make friends that they probably wouldn't have come across at an international school. So that was kind of neat. And so, yeah, we made a lot of friends. I enjoyed my colleagues at NUS and in the legal profession. And then it was a terrific place to travel from too, because, you know, it gave us an opportunity to explore a lot of places. And we took full advantage of that.
Great. So what are sort of your thoughts on Singapore developing itself into a leading arbitration hub in the world, you know, building on its deep academia strength, building on a strong arbitration bar, which is also why, you know, ICC Singapore is having such events, as well as building on a good infrastructure and a robust judiciary. What are your thoughts on that?
Well, I think that it's turned out to be a brilliant public policy development for Singapore. One of the things that became clear to me when I worked on the academy was just how well suited Singapore and Singaporeans are for international practice. And it has a lot to do with the facility in English. It has a lot to do with the transplantation of English common law. It has a lot to do with the educational pattern too, because you see so many bright Singaporean lawyers who will do a graduate degree in England or in the US typically. And so they already become even more attuned to these major practice centers and major legal hubs. So Singapore, when you look at Asia, for such a small country, it has a huge comparative advantage because of those human capital assets. And then you combine it with this sort of national characteristic of striving, which is unique in the world as far as I can see. And then excellent infrastructure, a place that people like to go to, very good local bar, excellent judiciary. And it's it's easy to see why Singapore is becoming a very successful international commercial center. I was really interested to find, this is an anecdote that just to illustrate the point of unexpected benefits of what has been done in Singapore. A lot of the investment that's gone into Latin America from Asia, investment contracts and that provide for SIAC arbitration.
Oh,
yeah.
Wow.
So I was surprised. I found this out in doing some Latin American work, and I was very interested to see that there were investors from Asia who were providing for the resolution of disputes instead of in New York or Miami or LA, they were providing for resolution disputes in Singapore. Now, whether those contracts will ever give rise to disputes which come to Singapore, who knows? But I have no doubt that the arbitration practice in Singapore will continue to flourish.
Yes, and in fact, it's interesting because when we look back and we look at the Laos and Sanum case, which was then the first, since then there've been another 2 or 3 others. And we do see this entire investment arbitration space expanding. And there are many states and many sort of investors also and tribunals where the seat is not decided, who choose Singapore as a seat where parties can't agree. We do have about 7 minutes left, and I think it's important for me to pick up some questions from the audience before going further and asking you about other aspects of your story. But I have a question from Ms. Smita Menon, where she says, young aspiring arbitration practitioners worry that they cannot distinguish themselves in what seems to be a very saturated market. What would you say to them?
Well, that's a very good question. And it's, the circumstances are different now than they were when I was starting off. I guess what I believe is, number one, the most important thing that a young lawyer should do is to try to get as much experience making submissions as possible, whether it's in court or administrative tribunals. It doesn't matter where. They just need to learn how to make submissions, how to keep their guard up, how to organize themselves, etc. And for me, probably some of the most salutary lessons in my career have been being slapped around by trial judges for making a mistake. And that teaches you to keep your guard up, and it means that you might make a mistake, but you won't repeat it. And you'll be a stronger lawyer for it. So I really believe that getting as much litigation experience as possible is the key to begin. The other thing is, I know that there's a lot of people who want to instantaneously get into this area of practice, but there's a lot of people who didn't get into this area of practice, who are very successful in it, who practiced in another area beforehand. And so I would say to the questioner to try to have some patience.
Yes.
Get as much legal practice experience as possible. Keep an eye out for the opportunity. And maybe that means you have to move firms. Maybe you have to go to a firm that has some of that practice. But even when you go to a large firm, it may not be a firm that has that type of practice, because it really takes one client that will go with the firm, and hopefully the firm does well, and that leads to more work. So it's a combination of patience and focusing on what's there. And I had a senior lawyer who told me once, this was back in the days when advertising was not permitted in Canada for lawyers. They now permit it, but his point was, you don't need advertising. He said, what you need is to make sure that the work that's on your desk is the best work possible, because whatever you do, if you do well, it will lead to something else. And that's really what's happened in my instance. So I don't think I provided much guidance on how to get exactly into this, but that's my basic philosophy. One other thing I would say, and it is a tried and true way for young lawyers to get into this area of practice, is go away and do an LLM at a top school, and then apply from there to some firm like Freshfields, Free Crown, Sherman and Sterling, any of the big players in Europe or in North America. And if you can get a job as an international associate for a couple of years, then that might lead to something else. You may never become a partner in those firms, but it still doesn't mean it won't be valuable. And I'll tell you a case, an interesting little story about this, and how an experience, even for a short time at another firm, can help people. I did a case a couple of years ago involving a claimant from an Eastern European state and a respondent from Eastern Europe.
Mm.
And the firm that was acting for the claimant was from, I would not call them, it was not a mainstream legal market. But they were all young lawyers and they spoke excellent English and they were really good. And there was one woman in particular who, she did a great cross-examination. And at coffee, a couple of days later, I said, where did you train? And she said, oh, I was at Clifford Chance for 3 years.
Oh.
So she had picked up the skills by junioring at Clifford Chance and then had gone back to her homeland and ended up being in a firm that picked up a claim. And one of the things I've noticed in my practice is 10 years ago, all the claims were being brought and defended by the major firms of the world. You know, the firms that everybody talks about, the great big firms. Now, in the last 5 years, I've seen many more small, unknown firms show up, and they do great jobs. And it's obviously because they've got lawyers who have worked somewhere else and then come back and join the firm, and they've managed to find a client who wants to bring a claim. So, you know, that is a tried and true way to get in and get some experience with an international law firm. And you may not stay there, but you may get some skills that will then give you some credibility if you're then talking to a would-be client.
Great. Thanks so much for that. You know, earlier on, you mentioned how it is so important to ensure that you're well prepared for the case. It's so important because it is really that one shot with the tribunal, because the realms of judicial review or setting aside of an award are so limited. Then it does bring us back to the very constitution of the tribunal, where choosing the right arbitrator seems to, you know, matter a lot. And having been a counselor, having been and still is an arbitrator, and also having worked with governments, what are your sort of tips on choosing the right arbitrator? Whether is it a party-nominated arbitrator or trying to get the parties to agree on the chair? Can you share some thoughts on that?
Sure. For the party-appointed arbitrator, first of all, I used to ask around a lot. So when I was trying to appoint an arbitrator, I would, because in those days, there weren't that many people who were doing this. It's different now. But I would, you know, I'd take a look at whatever I could read about the awards that person had participated in. And then I would start phoning people and asking them for confidential assessments of that person. And I wanted to find people who had worked with them to try to make an informed decision. All of that said, I think what you're looking for at a minimum is, number one, somebody who will prepare and will spend the time that is necessary to get ready for the case. And that sounds so basic, but it is very important, because there are some arbitrators who kind of fly by the seat of their pants. I'm not going to, I mean, you know, they're not prepared. And so at a minimum, you want to get somebody who is committed to preparing. And sometimes that means taking somebody who is less experienced because they don't have the heavy caseload and they want to make an impact. They want to, you know, they want to do their best. And so that is a really important issue. I'm not a big believer in trying to game out how somebody has decided previous issues, unless it's a specific issue, which I know is a really important issue to my case. And if they've been on a tribunal that went the other way, then I wouldn't appoint that person. But I'm not a big believer in gaming out things, because the whole process of how the decision is ultimately arrived at is driven by the facts, first and foremost, in my view, and the law will always follow the facts. So as long as somebody is legally competent and is a good writer, I'm more concerned with whether they'll be prepared. Number one, will they put in the time? and how will they get along with their colleagues?
Yes.
Because they might be well prepared and put in the time, but if they can't get along with their colleagues, that's not going to be helpful.
That's correct.
So that's what I think on a party appointed arbitrator. On the presiding arbitrator, there's been a movement in the world, for me at least, and that is, in the old days, everything seemed to be either the parties appointed the presiding arbitrator directly, or the two party appointed arbitrators would be like couriers, and we would be told by each side, oh, hey, here's 6 people, go off and try to convince the other guy or the other woman to take one of our 6. And the other person had exactly the same mandate to come and convince me to take one of their 6. And you go back and forth. I had one case where it went for over a year, going back and forth, shuttling back and forth. I found that very disheartening. And I don't want to do that, because I don't want to spend that much time talking to the party that appointed me. That's not to be, and I don't mean to be discourteous. It's that I don't want to do that. So about 5 or 6 years ago, a number of other like-minded arbitrators and myself began to say, when we get appointed, we'd email each other or call each other and say, let's take control of this process. And we would then write a letter to the parties and say, we'd like to propose that we pick the presiding arbitrator and that we consult you.
Yes.
And we'll talk to you about what you're looking for in a presiding arbitrator, what qualifications, is there anything special that you're looking for? And we would like to hear you on that, but we will come back with some suggestions. And we will ask you individually and confidentially to rank the, say, 6 people that we suggest to you. And we will take the person who comes back on those lists, which gets the highest ranking. And I like that a lot, because it cuts the connection between the appointing party and the arbitrator. And it allows the arbitrator, the 2 co-arbitrators, to form a little bit more of a cohesive start to the thing in finding somebody who they think would be good. And the other thing it does is it allows us to identify people who might not be thought of by the parties. Because I'll give you an example of somebody, I go by name. Jean Kalicki, who is now a very, very busy arbitrator.
Yes.
Was at Arnold and Porter. And I had her in a case years ago, and she was terrific. And I thought, she is great, and she will get as many appointments as she wants when she finally decides she wants to become an arbitrator. She then, a few years later, she retired from practice and said, I want to be an arbitrator. Mm-hmm. And I had 2 tribunals where I talked to the other arbitrator. I said, we came up with a thing, here's some of the usuals, but how about, let's think outside the box. And I said, how about Jean Kalicki? Great, I love Jean Kalicki. I had her in a case recently. And so we appointed her because we thought she was a great up-and-coming lawyer, and she's now well ensconced as a presiding arbitrator because of that sort of thinking.
Yes, and Chris, you may not know, but it's way past an hour, and that just shows how such a great time we are having. I will ask you one last question. What is the next chapter of your story?
Well, I'm working on a book manuscript right now. I don't know, I'm a little nervous to call it a book. It's long. I have a 1,200-page chronology that I put together, and I've got 5 very, very rough, 2 long chapters. But I'm doing I got interested in the Alabama claims arbitration of 1872. And the reason for that was I'm supposed to give a speech at ICA next year on arbitration's contribution to peace. And I thought, I'm going to find out why Andrew Carnegie built the Peace Palace, because he paid for the construction of the Peace Palace in the early 20th century. And it turned out that Andrew Carnegie, who became immensely wealthy, was greatly influenced by the Alabama claims dispute, which basically reduced the prospect of war between Great Britain and the United States. And so I thought, oh, I got to learn about this. So now I've learned about it, and it's been astonishing, and I've learned so many interesting things. And I'm trying to write the untold story of the Alabama claims arbitration. So that's what I'm working on in my spare time.
Goodness, that'll be a very exciting read, I'm sure. Thank you, Chris, for sharing your story with us, which I'm sure everyone here thoroughly enjoyed. This does lead me to call an end to the Arbitrators Studio, much as I would like to continue chatting with you. I would like to thank our participants. I would like to thank the ICC Singapore Arbitration Group for putting this together. I would like to remind the participants that if you are not yet a member of the ICC Singapore Arbitration Group, please do sign up. Membership is complimentary. And there'll be an annual town hall on 12th November 2021 from 5:30 p.m. to 7:30 p.m., where you can expect to receive updates on ICC Singapore events, nominations made to the ICC court by ICC Singapore, as well as a discussion on the implementation of the ICC Rules 2021. If you would like to register, you can scan the QR code, which is up on the screen, or follow the URL. With this administrative note, I would really like to give a great thanks and a round of applause, virtual applause, to Chris, and thanks so much for spending that hour with us. I know it's late in Vancouver, and I very much look forward to seeing you in person soon.
And I look forward to seeing you again, Sui, too, and give all my regards to our mutual friends in Singapore.
Yes, I will do that. Okay, thank you everyone for staying with us. You may now proceed to log off from the webinar, and if you can, please fill out the feedback form that will pop up on your browser.
Okay.
Thank you.
Bye-bye.
And goodbye. Thank you.